Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. Be seated. All right, Mr. Rain, did I say that correctly? Ryan, glad to hear from you.
Good morning, Your Honors.
Good morning.
I'm Bert Ryan. I'm representing Dr. John Oberg, relator in this case, an appellant. This is the second time this panel has had this matter before it. In the first,
You don't need to remind us of that.
right? And fair enough. And we would have been happy not to come back with the correct result below as well. In the previous decision, the court addressed framework, the analytical factors which could be used to determine whether a particular state-owned entity created by the state and operating a business venture was to be deemed a state agency on the one hand and thus not a person within the meaning of the False Claims Act, or other than a state agency and therefore a person within the meaning of the Act. And the court said that the four Hoover factors, which are non-exclusive, which are used to determine whether an entity is an arm of the state, would be equally useful in this context. So you've made law for the Fourth Circuit, aligning it in a general way with the tests in many other circuits. Upon that determination, plaintiff sought and secured permission to amend his complaint to more realistically describe the operations and status of the three defendants that remain in the case. And based on those pleaded facts, and taking them into account as they had to, the defendants continued to move based on the statutes which they had put before the court the last time, which they claimed established that they were state agencies. The question today is whether on the well-pleaded facts of the complaint and the reasonable inferences to be drawn therefrom, Dr. Oberg has plausibly stated facts which could lead to the conclusion that these entities are other than state agencies. If that is the case, then there's no basis for the grant of a 12b6 motion, and the case has to be reversed and remanded. And that's the relief we seek today. I just wanted to make clear, because it came up the last time, that Dr. Oberg was not a moving party. He opposed the 12b6 motion and stood on his complaint, and he is entitled to the assumption that the well-pleaded facts are true and the inferences therefrom. Certainly in the district court's opinion, there's no indication that the district court was doing other than trying to make a freewheeling determination of what he thought the entities were without regard to the bounds of the pleadings. And I think that's a flaw which we've pointed out. But this court is certainly free at this time to look at the complaint, to look at the facts pleaded therein, and to see how they would, in a court's judgment, fall out under the four non-exclusive Hoover factors. So I would like, if the court will indulge me, to talk about each of those factors, what is said about those operations in the complaint, and the conclusion we think they should lead to. And I'll just put it in context. These factors are not determinative in and of themselves. They are factors that are looked to answer two fundamental questions, which the Supreme Court has said are the pillar of arm of the state. One is, what's the impact of any judgment likely to be on the state treasury, on the ability of the state to conduct its ordinary business? And second, how is the dignity of the state affected by having these entities brought before a federal court and made answerable for claims, false claims against the federal government? Those are the two base questions, and the Supreme Court has said the various factors are used to answer those two fundamental inquiries. I think what we've established is there is no potential impact on the state treasuries as such, and I'll explain why, and that given the way the states have set up these entities and allowed them to conduct nationwide business under the supervision of their boards of directors, with the state holding only indirect and shareholder-type powers, the dignity of the states is not involved in this case. It is not an insult to their dignity to make these entities accountable for their business actions. So I think it's...
Is it possible, as I understood your introduction, you are going to go factor by factor? We have 3 states here, and for my own purposes, it might be more useful to go state by state. If you can't do that, though, I understand that you've prepared your argument.
No,
go whichever way you want to.
I'm happy to do it. I mean, and of course, I just want to be clear, we're not talking about the states, we're talking about the entities.
I understand, but I was shorthand manner talking about the entities from 3 different states.
Correct.
There you go.
But there are certain things that are in common. So when we turn to the Treasury factor, and we can say one by one, is there any obligation imposed on the states by state law to fund these entities and, importantly, to meet their obligations and losses? Because in that factor, the court has to take account of the Supreme Court's decision in Hess. In Hess, Justice Ginsburg was applying arm of state test to PATH, which is an entity created under an interstate compact. But she did analyze the arm of the state factors. And in addressing the Treasury factor, she said you don't focus on profits and surpluses, that is, the investment benefit to the state that might accrue from a successful operation. You focus on debts and losses and ask, is the state going to be accountable for debts and losses? Now, in each of these cases, the states have sealed themselves off intentionally, saying we're not responsible for paying their bonds, we're not responsible for paying their debts. We are not putting forth a statement of responsibility. There's no record in any of the 3 states that, I'm talking about the state level now, that they have provided continuing financial support for the operations, the dominant lending operations and acquisition of loan operations conducted by these entities. So you can't show it on a statutory basis. You can't show it on a historical basis. And when we look at the realistic risk assessment, do these entities have the resources to meet any judgment that might be entered in the case, you come to the same conclusion. So if you're trying to determine, can there be an impact on the functioning of the state government through its treasury, no matter which of the 3 entities, whether it's FIA or VSAC or ASLA, there is no commitment by the states. No one can point to one. You can speculate about what they might do, but speculation isn't the same as demonstration. And there's no history of the states as in, let's say, in Risto, where the state was responsible for the payment of interest and principal on loans, where the state had historically pumped money into the Ports Authority in order to create a better port system for the state. There's nothing that's happened over the history of these entities that shows that there's any commitment by the state to pay. So I think on that factor, and again, it's not determinative because the Supreme Court says you've got to look at them all. On that factor, there's no real basis to determine that the states are put at risk as the 11th Amendment contemplated for their essential operations. Because the 11th Amendment, after all, is intended to say you cannot use the full courts to jeopardize the continuing viability and function of the states. So I don't think on that factor there's any difference between these entities. Now, they do have, and they have made arguments which are largely circular. They say, well, if the state says that you have to put your money in the state treasury, now it's state money, and therefore that's the end of the argument, because it'll always be paid with state money. But those are assumptions of conclusion. The fact that the state acts as their depository, put your money here, even though you control it, we can't use it for other state purposes. It's yours.
Well, it's not accurate, though, in every case that the authorities absolutely control the expenditures, is it?
No, they don't.
I mean, like in Pennsylvania, doesn't the governor have to approve bond issues?
He has to approve bond issues.
There's a statutory limit on how much debt can be incurred. So it's not quite as black and white as you're saying, is it?
Well, I think that the question here is, who's going to meet the obligations? Once
exactly.
the governor
but
has...
in terms of, what doesn't autonomy have to be considered as well? I mean, you're looking at the one treasury factor, but it seems to me that, case law is pretty clear that isn't a single predominant factor, that you have to look at the others. And
I've said that, and we agree with that. Okay. And let me address autonomy, because autonomy has several sub-factors in case law, one of which is some degree of control. How do these, and particularly historically, how have they controlled these activities? I mean, these entities have broad scope of authority. Their directors can pretty much go into any business they like that's within the
The
general.
directors are, in almost every case, appointed by the governor or some other state official. And as I read the cases, that would count against you with respect to autonomy.
Well, I think it's clear that if they were appointed locally, it would be a different case. But we've recognized that. But the real question is that a means of exercising control? Are those directors carrying out the will of the state, or are they simply qualified persons who are protecting the entity and acting in a fiduciary capacity? And I think if we looked at the record of how these entities have operated, they're really the second. And one important part of the autonomy factor is, where does your money come from? Are you self-sustaining? And certainly in Hess, that was a very important consideration for Justice Ginsburg. She said, this is an operating entity. You generate your own funds, even though part of its overhead was directly furnished by the states, and it so says, but she made it a major consideration that they could self-fund, because if you pay the piper, you call the tune. If the
But
entity
they generate their funds with approval from the governor. Isn't
not
that
entirely,
correct?
because there are two kinds of operations. They do servicing operations, and right now that's a very important part of their function. They don't need any approval to go into servicing businesses. They do need approval to issue bonds, but they can also make loans that are not in the form of bonds, as we showed in the case of Arkansas, and they don't need approval. And the real question is that approval a serious consideration by the state, or is it a pro forma exercise, really not protecting the function of the entity, but looking at the overall financial picture in the state and certain federal restrictions, particularly on loans that are issued on a tax-free basis? So I think that, again, that's something that could be tested in reality. What is the real-world limitation on these enterprises? They are able to grow, triple their activity with no record or no interference by the state in very short order. They have tremendous real-world latitude. And I think the cases say you can't just look at this abstractly. You have to look at whether they're operating as arms of the state in the real world. And so in all of these cases, as the facts pleaded show, they radically changed the composition of their activities in order to take advantage of this federal benefit. There's no indication that the states were asked or approved or even considered it. The states are investors, and they're certainly interested in making money with these enterprises. But that, a state investment, does not transform an entity into a state agency. And so that if we, the fourth factor, which is how are they treated under state law, a couple of things that really kind of stick out in that regard. They're given this broad latitude. They're given enormous power to conduct any enterprise they want, so they're not treated as a closely controlled agency. They don't have state officials as such directly managing them, because even in Port Authority, the governors had veto power under the actions of the path. There was a direct reporting responsibility. The governors appointed all of the directors. So that can't be determinative in and of itself. And what the states did here was to empower them very broadly, and the states permitted them, and particularly in the case of FIA.
One of the things the courts have looked at under this factor is how the state court treats the entity, and the state court treats each of these entities as a state agency.
Well,
now, you may not agree with those decisions, and there have been circuit courts that haven't agreed with that, but I haven't found a court that has said that that doesn't weigh in favor of saying that they're treated under state law as a state agency. Now, if you have a case that says that doesn't matter, I'd be delighted to hear about it.
Well, I'm not going to tell you that it doesn't matter, that it's not one of the many things you take into account.
The only thing we're looking at now is even though you told us you were going to do it, I thought you said to me you were going to do it state by state. You haven't done that.
All right.
And so you argued that all these states are exactly the same. All God's children are the same. And I actually don't think they are all the same. But that's your choice to argue the case whatever way you want to. But with respect to how they're treated under state law, they are all the same, because state courts, maybe the decision was a long time ago, but the state courts have treated all of these agencies at one time or another as state agencies.
I think if we differentiate that agency by agency, the FIA has a track record of being treated for certain purposes by state courts as state agencies. As you know from Ramdita, and the same is true in Hess, that is a factor and has to be considered. It is not determinative.
None of these things are determinative.
Absolutely.
It'd be good if the Supreme Court decided what was determinative, but now
As I say,
nothing is.
But then if you look at ASLA, Arkansas's entity, it's slightly different. They have some dicta, but they don't have a direct holding by a state court. And in the case of Vermont, there is no state court treatment. There is nothing to rely upon except speculation as to what a state court might say.
Yeah, but Pennsylvania's really strong, isn't it, in terms of its appellate decisions? I mean, it says FIA is the Commonwealth.
Yeah.
I mean, the case is uniformly, the court is not only referring to FIA as an agency, but it describes it as the Commonwealth. And then describes it as akin to a department, administrative board and commission, and other agencies of this Commonwealth. FIA is such an agency. I mean, it's just uniform in Pennsylvania. There doesn't seem to be any ambiguity in how the courts treat it. So isn't this something we have to pay attention to?
And I said, it is certainly a factor. I don't think, as I said in the beginning, you have two paramount questions. What's the impact on Treasury? How's the dignity of the state involved? And this is, I don't think, we're not disputing that you can take it into account. I do think...
well, why isn't it a strong consideration in terms of the Pennsylvania appellate decisions?
I think that what you see in Ramdita, there was a direct holding by the Maryland courts that the Parks and Planning Commission was a state agency. It was a direct holding. And the court said, yes, it is, but this is ultimately a question of federal law. So you look at the whole network of treatment. State courts may, for the purposes of the lawsuits in front of them, say, yes, we're going to treat this as the Commonwealth, the state agency, and the management of personnel. That's what they've said. But that is not in and of itself a determinative factor. And just as I think we would say, and our opponents would say, if
when were
Treasury
the cases decided? Do you remember?
Which case is this?
The state court cases holding this is a state agency under state law in Pennsylvania.
That's right. In Pennsylvania, I think some of them are quite old. I
think they are old, and I think your argument probably would be that this agency has changed in its identity, function, et cetera, since that time.
Well, it's radically...
But you haven't made that argument, so go right ahead.
Well, I think I'd certainly accept to throw my arms around it now. They are old cases. I think they're premised on the formalism of ownership.
Well, some of them are from the 80s, though. I mean, I don't know about you, but I remember the 80s.
Well,
what about FIA has changed in your understanding to make those cases no longer applicable?
Starting in the 80s, these entities went from being primary lenders to being financial players. The advent of asset-backed securities radically changed the nature of their operations. They were set up, and if you look back, they're set up in the 70s. The idea was you'd raise money and lend money directly to students in your state or who were graduating and moving on to other states. When they got into asset-backed securities, which gave them the ability to go in the secondary market and buy loans as financial assets without regard to whose loan it was, where it originated, where it was going to be paid, that changed, expanded, just completely, if you want to put it in modern terms, morphed the nature of the operation.
You're saying they're different creatures than they were.
Different.
Okay.
And certainly, if you look at their financial history, they're radically different. And that is something this court has to take into account, because the question is, what were they at the time that the alleged offense was committed? Because that's in the words of the act. A person has to commit the fraud. So the question is, when you did the act, were you a person? So I see I'm running into my time, and I'll desist.
Let's hear from the other side.
Thank you.
You've got some time remaining on reply.
Thank you.
Happily.
May it please the court, it's an honor to be here again. My name is Dan Hewitt, and I represent the Pennsylvania Higher Education Assistance Agency. With me today is Bart DeLone. Mr. DeLone is a senior deputy attorney general from the Commonwealth of Pennsylvania. The guiding principle in this case was articulated by the court in the Oberg decision as follows. The critical inquiry is whether the entity at issue is truly subject to state control to render it a part of the state. Deciding this critical inquiry, using the words subject to, means that this critical inquiry can be accomplished by looking at the state's laws alone. That our state's laws alone are enough to decide this critical inquiry, that FIA is an arm of the state, is one of the holdings of the Regions of California and Doe Supreme Court decision, where the Doe court said, and I'm paraphrasing, the question whether a particular state agency is an arm of the state is a question of federal law. But that federal law can be answered only after considering the provisions of state law that define the agency's character. So the Supreme Court has instructed that in determining the arm of the state, you look to the state laws to determine the agency's character. This is not a new approach for this court. This is precisely the approach that the court used in Hoover and used in Maryland Stadium Authority when the court determined that both of those entities were arms of the state. Now, Mr. Oberg's new allegations in his Fourth Amendment do not alter this approach at all. They do not alter the approach that in deciding the critical inquiry, the court should look to the state's laws alone. This case has never been about the sufficiency of Mr. Oberg's pleading a person. It can't be, because the state's laws alone are what determine whether or not FIA is a state agency. This case is far too important to depend on Mr. Oberg's creative pleading, where he simply extracts arguments from his briefs and imports them into his amended complaint. Nevertheless,
how do you respond, though, to the argument that leaving the statutes aside and the requirements for the governor's approval and statutory limits on spending and things like that, that the Pennsylvania cases are old cases, and we're talking about an agency that has changed so much that we can't really accord much weight to those cases?
Well, the cases are not that old, I think, as Your Honor pointed out. But there's a recent case. In fact, it's a 2013 case. It's an Eastern District of Pennsylvania federal case called Lang. And in Lang, the issue was, under state law, whether FIA was qualified to be qualified for the state's sovereign immunity statute. And in making that determination, the Lang court held this year that FIA was a state agency. Now, with regard to the change...
Case to us?
I'm sorry?
Is that case cited in your papers?
Yes, it is, Your Honor.
Okay.
With regard to FIA's change, there's been no change here. Every activity that FIA engaged...
Well, the amount, according to your own reports, the amount of money that you are controlling has changed enormously. I can't believe that with a straight face you're you're denying that.
Well, I don't deny what the financial statements hold, but let me finish.
Well, and don't they reveal just exactly what I said?
Well, Your Honor, they reveal that FIA has made money over the years. But if you look at...
No, not made money. I mean, I should make so much money in the way that they have made money. They are a national player, as you put it now, where they weren't at their outset. Isn't that true?
The answer is yes and no.
No?
Yes. The answer is that do they conduct activities outside the state of Pennsylvania? Yes. Does any state university do that? Does the University of Maryland do that? Of course they do.
Well, what did you say in your report about how much of your business was outside the state?
I don't think there's a breakdown of how much there is outside the state.
I think you said, as a report about 2 years ago, that more than 25% was outside the state?
Your Honor, I don't call it a report. If that's what the report said, I certainly have no reason to disagree with that. But let me point, Your Honor, to the simple fact that the state's statutes authorize FIA to do business out of state. So the state...
Oh, yeah, there's nothing wrong with doing business out of state, but this isn't a small bank, Pennsylvania bank.
I think what's important to recognize is what does FIA do with the revenue that it has earned? Yes, does its revenue exceed expenses? Yes, but what does it do with that money? It uses that money to fulfill its statutorily imposed mission to provide greater access to Pennsylvania students and their family to higher education. That's what that money is used for. For example, Your Honor...
Well, what do we do about the provision in Pennsylvania law that I don't see a similar provision in Vermont or Arkansas law that said that the state avows any liability?
Well, that's not precisely what the statute says. And let me answer that question very directly.
Okay, I'll go to the statute. together.
The statutes that provide that.
Wait, just wait.
Go ahead.
I'm very
Go
sorry.
ahead. I'm with you.
Okay, go ahead.
The statutes that provide that the Commonwealth will not be responsible for a debt of FIA relate to its voluntary indebtedness. That is that when FIA takes on bonded indebtedness, and this is not unusual when a state allows a state agency to issue revenue bonds.
Well, it's not in either of the other two states.
Fair enough.
May not be unusual, but of these three, it stands by itself.
Well, there's an entity in Pennsylvania called the State Higher Education System, which administers the state universities, which has the very same provision. But it has been held in the Skian case that it is an arm of the state nevertheless. But the statutes that we're talking about, Your Honor, relate to voluntary indebtedness, principally bonded indebtedness. And it's not unusual.
No obligation of the agency shall be a debt of the state, and it shall have no power to pledge the credit or taxing power of the state, nor to make its debts payable out of any monies except those of the corporation.
Yes, Your Honor. And if I could point, Your Honor, to the sentence that remember it has the conjunction but. So the phrase that precedes that is absolutely applicable to voluntary indebtedness that FIA incurs. It says that when FIA incurs voluntary indebtedness, such as a revenue bond, it does not allow the agency to pledge the full faith credit of the Commonwealth. And that's typical in these kinds of financings. And that's because the bondholders look to the assets that secure the revenue bond. They do not look to the full faith and credit of the Commonwealth of Pennsylvania. There is no statute, and Mr. Oberg has cited no statute, that says that in the event that there is an involuntary debt, that is one.
What do you mean by an involuntary debt?
I was just going to explain that, Your Honor.
Excellent.
An involuntary debt would be, for example, if Mr. Oberg were to secure a judgment in this case. That's obviously not a debt that FIA has agreed to take on. It is a debt that it is a judgment that occurs as a result of litigation. There's not a statute that Mr. Oberg is pointing to, because there is none, that says that in that instance the Commonwealth will not pay the judgment.
No obligation of the agency shall be a debt. I don't understand how that means what you say it means.
Your Honor, I would ask the court to put that in context in which it is stated in the statute. That sentence begins, the board may, with the approval of the governor, borrow monies by making and issuing notes and bonds. And then it goes on to say, but no obligation of the agency shall be a debt of the state.
Right.
It's clear to me that that but conditions the preceding phrase.
The agency can borrow the money, but no obligation of the agency shall be a debt of the state.
Exactly. That does not apply to a judgment that's obtained through litigation. But
They even added they even said that this was not severable from the rest of the statute. It was so important. And then it goes down further and says, all accrued and future earnings from the funds may be utilized at the discretion of the board of directors for carrying out any corporate purposes of the agency.
Right.
Any placement of such funds by then state treasurer and depository shall be consistent with guidelines approved by the board of directors.
correct. And
It sounds like the board of directors are controlling things.
No, Your Honor, the purpose of the agency is articulated in 5102. The purpose of the agency, which is
I
the
read that
corporate
purpose.
purpose, is to improve the higher education opportunities of persons who are residents of the state. And the discretion, of course, by the board of directors is tempered by the very tight controls, the very tight fiscal oversight that the state treasurer has. All of FIA's money must be deposited in the state treasury. And by the way, Your Honor, in Maryland Stadium Authority and Hoover, that was really enough to show that
But that's just exactly the opposite situation that we have here, since the agency was the plaintiff in that case, and the agency is the defendant here.
Well, Your Honor,
And not only our court, but the Supreme Court has made that distinction, which you say isn't important in your brief, but maybe you can make new law in the Supreme Court. But
well,
that's
Your
not
Honor,
the case.
we hope not to make new law in the Supreme Court, that's for sure. But let me just finish.
Can I ask you about one, just before you sit down, one case that is you mentioned in a footnote only in your brief, which is from the 1st Circuit, and it seemed to me that it was the case that was closest on the facts to this case. Do you know what I'm talking about?
I don't have a recollection of that as I stand here today, Your Honor.
Okay. Well, maybe I can help you find it then. If you look at your brief, and I think that you acknowledge that it is close because the way in which you distinguish it is pretty minor, shall I say. It's on page 49 of your brief, I believe. And you say your lack of ownership and control distinguished the First Circuit case where the state treasury engaged in only limited monitoring of board revenues and expenditures, and no state law permitted state intervention in the university's income stream. But in fact, in that case, as in this case, you had money coming in from the pursuit of the entity, University of Rhode Island there, and going into the state treasury, but being earmarked only for Rhode Island, the University of Rhode Island's activities. And the First Circuit held that even notwithstanding that, the University of Rhode Island was an arm of the state. That
Yes,
seems to me exactly like your situation.
Well, I think
It's just you think First Circuit is wrong.
Well, I think what's critical about our situation, Your Honor, is how that money is controlled by the state. I mean, if you look at the other three factors, which we know that...
I understand your argument about the other three factors. I mean, I think I get that. But with respect to this factor, the first factor, it's on all fours.
Well, I think that when you look at the test as was established by Maryland State Authority and Hoover, the test was twofold to meet this first requirement. And that is, was the money deposited in the state treasury? That's what Maryland Stadium Authority held.
Because it was inuring to the benefit of the state, because the state, the entity there was the plaintiff, and the entity is the defendant. So you're looking at whether the state is going to be hurt in this situation, not whether this is inuring to its benefit, because it certainly isn't.
Well, I disagree, Your Honor. I think that the critical factor here is the critical inquiry that the court framed.
Okay.
Is it subject to the state control? And is the state revenue that FIA deposited in the state treasury subject to strict oversight and control by the state? And it quite clearly is.
Okay.
And that means...
Thank you very much. I've kept you longer than your time.
Okay. Thank you, Mr. Hewitt.
Thank you, Your Honor.
Let's hear from Mr. West.
Good morning, Your Honors. May it please the Court. I am John West. I'm here on behalf of the Vermont Student Assistance Corporation. The District Court correctly concluded under the arm of the state test that VSAC was under sufficient state control to render it a part of the state. And I want to walk through each of the four factors that are a part of this analysis. And as to the Treasury factor, it is important to focus on the state statute that Vermont, as a state, shall support and maintain VSAC. And to that end, Vermont has made annual appropriations to VSAC and provided it funding each year of its existence. And in many of those years, there have been state funds that have been available to VSAC for its operations. Now, there were years when the operations and the revenue that VSAC was generating did not require that it use state-appropriated funds for its operations. But in recent years, the last 4 years, there have been the need for that, and the state legislature has actually made, as a part of its legislative grant of those funds, it is set aside that a certain percentage of those annual appropriations could be used for the operations and therefore are unrestricted funds. And the import of that is that, first of all, that there are state-appropriated funds that are unrestricted and held by VSAC that would be subject to a judgment if one was obtained by Mr. Oberg. In addition, it does demonstrate that over the course of VSAC's history, the state has had a relationship of providing funds to the entity, and on particular years, those have been available to support and maintain the entity. Finally, the state does provide, or the state statutes do provide, that all of the net earnings of VSAC incur only to the benefit of the state. And the importance of this is that the assets and the money that VSAC holds at this time is ultimately the state's money. And so when addressing the critical question that this court must have on the Treasury factor, we submit that there would be a detrimental impact to the state Treasury of a judgment rendered against VSAC. Now, the second factor is the degree of autonomy, which the court has focused on. And there are several key indicators of the state's control over VSAC. VSAC's primary function is to issue debt to support its lending and its grant activities. And VSAC does not have the authority to issue any of that debt application without first receiving the approval in writing of the governor. There's also the indicia of control, as has already been noted, that the state controls VSAC's board. And out of the 11-member board, 8 members of which are either current elected Vermont officials or appointees of the governor. And the chair of that board can only be appointed with advice and consent of the governor. Other indicia control are that VSAC must file biennial reports to the legislature. It must file annual reports to the legislative's educational committees. Its books and accounts are audited on an annual basis. And finally, the state has maintained ultimate control over this entity. And by statute, it has the authority to alter, amend, or otherwise change the structure, the organization, the programs, or activities of this entity, including the power to terminate the entity itself. And this demonstrates significant control that the state has maintained. There's the third factor that deals with whether Vermont focuses on state concerns. And yes, VSAC does do business outside of the state, but it is clear that its core function has not changed. And that core function is to provide both lending services but also educational opportunities for Vermont residents and others coming to school in Vermont.
Do we know from the record here, or from the public records, I guess, that are cited, how much of the resources are used in Vermont?
Your Honor, I do not know whether that is broken.
I thought it might be. In Pennsylvania, they had some reports, annual reports that they'd file. Yes. So we know something there.
I'm not sure whether that is broken out
in the record here.
I'm not aware of whether that's in the record.
Well, you would know, right?
Yes, Your Honor, and so I'm not able to cite that to you. But it is important to recognize that VSAC's lending program is available not only to all Vermont residents, regardless of where they go to school, even if they go to school out of state, but they also make loans to students from outside of the state who come to school in Vermont. And as a result, when those students go and finish school, VSAC continues to service those loans regardless of where those individuals reside. And therefore, there are activities outside of the state, but those are a part of and support the core function that VSAC has, which we submit is clearly a state concern. And finally,
I thought I had read in the papers that you were making a distinction between out of state and local, and you said that when we're talking about state concerns, we only look to see whether they are local concerns or state concerns. But you're not espousing that in front of us.
No, Your Honor, it is the case.
If you had all of your, or 90% of your activity was centered out of state, that would show us that that factor did not weigh in your favor, right?
Your Honor, that would...
Even if it wasn't a local.
Correct. Yeah, we are not making the distinction of local versus state, although that has historically been something that courts have focused on because of the entity.
I just want to be sure you understand my question. I had thought that you were making this distinction in saying it to be a state concern, all you look at was whether it's local or state, not whether it's state or out of state.
No, Your Honor, we are not making that argument.
Okay.
So finally, the fourth factor addresses whether the state treats VSAC as an entity. And Mr. Oberg has argued that VSAC is not a true state agency within Vermont, despite the fact that that is not a defined term within Vermont state government. And VSAC does have a different structure from certain agencies within Vermont. Example is the Vermont Agency of Natural Resources, which was subject to the case in Stevens. But VSAC was established as a state agency, in fact, 4 years before any cabinet-level agencies were created in Vermont. There are other agencies, the Vermont Department of Education, similar to VSAC, which are not designated as cabinet-level agencies and are, in fact, governed by a board like VSAC. These differences do not make VSAC any less of a state agency, but they merely demonstrate that the legislature of Vermont has made a decision to establish its various agencies in different ways. The state includes VSAC on its organizational chart listing agencies of the state. It requires that VSAC's revenues and financial activities be included in the state's annual financial report. And all personal and real property of VSAC is exempt from taxation. These activities demonstrate that the state, in fact, does reflect that it treats VSAC.
Mr. West?
Yes.
Your red light's been on for about 5 minutes.
Oh,
You're out of time. I'm sorry to cut you off, but...
Yeah, I apologize, Your Honor.
Mr. Connolly?
Thank you, Your Honor. Good morning. Tom Connolly on behalf of the Arkansas Student Loan Authority. With me is Mark Warrenbergen, Assistant Attorney General of the State of Arkansas. In its first opinion, the court noted that the critical inquiry is state control, and applying the arm of the state test, the Arkansas Student Loan Authority is unquestionably controlled by and part of the state of Arkansas. Let's look at the first factor, whether the judgment would be paid by the state. Now, the funds ASLA holds are all cash funds, which is a defined term in the Arkansas Code, referring to funds held by state agencies outside the state treasury. So ASLA's funds are by definition, state funds. Those cash funds are subject to strict statutory control under Arkansas law. ASLA cannot spend any of its cash funds without an appropriation or other statutory authorization, and ASLA's 2009-2010 appropriations bill is in the joint appendix at 411 to 14. It makes clear that ASLA's use of cash funds in its own accounts is subject to appropriation, along with a host of other state statutes restricting spending, including the state procurement law, the Accounting and Budgetary Procedures Law, the Revenue Stabilization Act, the Regular Salary and Procedures and Restrictions Act, and other fiscal laws of the state. There's no question that the state clearly exercises direct control and dominion, and that ASLA's money is subject to appropriation, restriction, audit, and budget planning, and meets the requirements of Hoover and Maryland Stadium Authority. Let me address a question that Judge Motz asked in the first hearing, and one that Relator argues here. Relator tries to argue that there's no state law clearly making the state responsible for a judgment against ASLA. That's because ASLA, as a state agency, is generally immune, at least in court, as part of the sovereign. And it's only in its contracts, like its state-approved bond indentures, where sovereign immunity is waived by statute, that ASLA can be sued in court. Under Arkansas law, claims against ASLA, like claims against other state agencies and the state itself, are referred to the State Claims Commission. And any award of the State Claims Commission over $12,500 is sent to the legislature for appropriation. So any federal judgment against ASLA would be sent to the Claims Commission and then to the legislature for appropriation. There is no other mechanism under state law for a judgment to be enforced against ASLA. And I note that claims against municipalities, counties, and local school boards do not go to the Claims Commission. So claims against ASLA are handled exactly the same way as claims against the state, and to be paid, they go to the state legislature for appropriation. I think that's dispositive. Let's talk about the second factor. ASLA's creation and every significant...
I thought that you indicated in your papers that the Attorney General represented ASLA.
Correct, Your Honor.
And that was... Are you an Assistant Attorney General?
No, Mr. Orenberger is my co-counsel, yes. Yes, the Attorney General, The elected Attorney General of the state of Arkansas, Dustin McDaniel, is
So the only
on the
one that
paper.
you can represent is the Attorney General hires you, is that it?
The Attorney
I mean,
General.
mustn't that be the case? I mean, if
The Attorney General did
represents-
authorize our approval, did authorize our hiring, and indeed in the
That's
appropriate.
the only way that an outside lawyer could represent.
That is in fact the only way an outside lawyer, that's in the appropriations bill in the appendix. ASLA cannot hire outside counsel without approval of the state Attorney General. ASLA has no taxing authority. It can neither raise funds nor spend them without express authority of the state. Its board of 7 is all appointed by the governor. They serve without compensation. There's no other level of state government that authorizes, that governs ASLA's activities. Every time ASLA issues a bond indenture, that bond indenture has to be approved by the State Board of Finance, made entirely up of state officials, the treasurer, the auditor, the director of finance, the bank commissioner, the governor. That must be then signed by the governor, who is in turn advised by the legislative council, made up entirely of sitting legislators. So indeed, ASLA's actions are subject to direct review and approval whenever the ASLA sells bonds, spends money, enters into contracts, sets its operating budgets, and sets salaries. On the third factor, I think, in making arm of the state determinations, the court has recognized that higher education is an area of quintessential state concern. And ASLA was established in the code as, quote, the instrumentality of the state charged with a portion of the responsibility of the state to provide educational opportunities. That's the Arkansas Code. And looking at the last factor, you have extensive sites in the Arkansas Code, a gubernatorial proclamation, a decision of the Arkansas Supreme Court, and my counsel, the elected Attorney General of Arkansas, all telling the court unequivocally that ASLA is a state agency. Now, against that backdrop, the court can only conclude that ASLA is exactly what the Arkansas Code, what the Arkansas Supreme Court, what the governor, what the Attorney General, and most importantly, what the arm of the state test says it is, state agency. Now, as to ASLA, this question is not even close. And for all the reasons set forth in our papers, the decision of the district court should be affirmed. And unless the court has any other questions, thank you.
Thank you. Ryan?
Thank you, Your Honor. I'll be brief. I don't want to test the court's patience. A specific question was raised about the age of the decisions in Pennsylvania. And
I think that that what you have here are a bunch of recent, pretty recent, federal decisions that some of them, most of them are unpublished, but they go the other way. So if your case rises and falls on how the state court treats your the other side, then I think we would have to say it is an arm of the state. So, I don't know if you want to spend a lot of time on that, because that seems to me.
No, I was just trying to. You asked me a specific question. When was the case decided?
Yeah,
that was
but
the foundation.
I can read that. If you have any
1970.
argument on the other three factors.
Yes, and let me say, as I said to you before, we're not saying that any single factor is determinative. This court did not make. These factors are non-exclusive.
I think we've got that.
All right, and so then we're down to the two base questions. Is there going to be an impact on the state treasury? And you've heard FIA say, well, there's nothing that says the other side, have not proven that the state will walk away, but the burden is really different. Do these statutes say the state will pay? If you look at the statutes governing FIA, the state disavows that responsibility expressly, and you pointed to that language. The control of the funds in the treasury is exclusively with the board of directors, and they can be expended at the discretion of the board. And that's how they've done it. That's what the statute says. If you look at Vermont, VSAC, and that relationship, there's nothing, and they've pointed to nothing that says the state will pay. They say, well, there's a general obligation to support, but no one knows what that means. That's entirely discretionary. So you cannot say on the statutes alone the state will be placed at risk for a judgment. And then when you get to Arkansas, they have the remarkable argument that we're not going to pay. So if they're not going to pay, why are they here? What is the risk to Arkansas if, absent a discretionary decision by the legislature, they're not going to pay anything?
What do you have to say with respect to the second factor, the autonomy factor, with regard to Pennsylvania?
Well,
Everybody on the board is appointed by the governor.
Right,
or
and that has
other.
been true in other cases, and certainly in Hess, the Supreme Court faced a situation where all of the directors were gubernatorially
I
appointed.
understand that, but so are you
And I
just
think-
giving up on the autonomy factor? Are
No.
there any facts with respect to the autonomy
It's the
factor?
self-sufficiency, which has always been a key to the autonomy factor. Are these, because as you say, that one part has always been the question, do you have taxing authority? But taxing authority is just a measure of being able to raise your own funds. All of these entities are self-funded. They don't need the financial support of the state. And in the case of VSAC, what they're talking about is a specific state grant program. It's an earmarked fund that they administer. And they were doing the state the favor of saying, we'll administer it free, but from time to time they've said, no, the administration of that program has to be charged just the way a contractor would charge it for the overheads of that program. But all these major programs, which are their dominant activities, have no state funding involvement whatsoever. They're self-funded, highly profitable.
Let me ask you again about the appointment power here in terms of the board members in Pennsylvania. Do they automatically lose their position still? It used to be the case, I know. They automatically lost their position when they no longer held public office. Is that still the case?
Well, they, again, we have
To your
to ask
knowledge,
that
that's still the state
there are
law.
now appointees who are private persons, so they're not even in
Right,
state
but
office.
all the state appointees.
We haven't seen anything that changes that
Mm-hmm.
appointment. They are, in a sense, ex officio, the legislators. Now, whether the governor's appointments would lose their status, I think is much more amorphous under that statute.
Mm-hmm.
But the legislative representatives are sitting in effect ex officio, but they're a minority.
Can you talk to me about the third factor with respect to Pennsylvania?
Well, certainly Pennsylvania has shifted its activities, so its dominant activities are outside Pennsylvania and are indifferent as to who is being supported by that activity. Because as we said, when they changed the nature of their business and they went into the
And
ABS.
is there a 2005 report?
Yeah,
And what are the statistics in that report?
well, it's 30% or more of their revenue comes outside. At the end of the FFEL program, for example, where they're no longer making FFEL loans, almost all their revenue today is generated by their servicing the federal government's supervision of its own loans.
But don't we look at the facts as they were when you filed your complaint?
And that's why we pointed
You
to...
agree we do.
I think that, yes, because we have to prove that the fraud was committed by a person. But what we showed
You
was...
have to allege enough to get by.
Ultimately, and I think
The
I'm
motion
just...
to dismiss.
I
I
agree.
mean, this case doesn't, even if you should win, this case doesn't necessarily go to trial.
I certainly agree with you. What I'm saying is I think there's a difference here. Ultimately, we bear the burden of showing person. That's why the question is, have we plausibly alleged person status to go through the motion period? They are free to contest, ultimately, whether we can prove that element by a preponderance. We're not walking away from that responsibility. But then we would have discovery. And I think what we've seen on the record is that they went into this enormous out-of-state, indifferent asset purchasing activity during the period in question. That's how they did it. And I think that, what we pointed out in the case of FIA is they tripled their base activity. They tripled their loan portfolio. So you now have 2/3 of that portfolio held without regard to what it is supporting. It's an asset. You look at it in terms of what's its maturity, how is it going to feed and support the bond issues which are tied to it. You no longer ask the question, whose loan is it? It can be a loan anywhere. It could be a loan in Hawaii to a student attending university in Oregon. It has nothing to do with Pennsylvania, but it's a good asset. So when you change your business and you start looking for good assets, and the state certainly has no limitation on their ability to do that, that's a very different situation. And each of them at least doubled, and in the case of FIA, tripled their portfolios. So they just radically revised the nature of the business. They had latitude to do it under state law, and they did. So I think that to say that the
I
dignity...
hate to cut you off, Mr. Wright.
I am.
I'm going to ask the clerk to check to see if that red light can be seen from the other side.
I think, unfortunately,
We're
Your
going to come
Honor,
down and greet counsel.
Cautionary
and-
tale.